Hello and welcome back. We're going to be covering Chapter 7 today, which is Community Supervision, Modification, and Termination. Let me just start by giving you a little story about my practical experience. Excuse me. You would think that if you have a probationer or somebody serving a community correction sentence, that if they followed the rules and they did everything by the book, that the judge would release them from supervision early. But that's not always the case. I had a specific case where this gentleman, he was an outstanding citizen in the community. He sponsored Little League Baseball. He maintained employment throughout supervision. He paid all his fines and never had a dirty urine. Reported every month. It's the ideal candidate for early release from supervision, which is a form of modification, early release. But I did the paperwork and sent it to the judge, and the judge denied his early release. So that being said, let me just jump into the lecture and talk a little bit about early release. It is possible for people under your supervision to be released early from their supervision sentence, be it probation, community service, or whatever. The general rule of thumb is they have to serve at least 1/3 of their sentence or 2 years, whichever is less. So what happens is, the way it works is like this. The supervising officer submits the paperwork to the judge, and the judge can approve it or deny it. There's no need to have a special hearing on it or anything. In fact, when you do your paperwork, you probably want to put a motion for release attached to your recommendation. But you got to remember, as I always stress, that we are just servants of the court and that the judge has the final word on everything. So let's talk a little bit about how many of our probationers actually do successfully complete their term of supervised release or probation. And on average, national average that is, about 60 to 70% of probationers are successful, and about 49 to 57% of parolees are successful. So what's the big deal about the difference between probationers and parolees? Well, or not such a big deal, but why do we see that difference between probationers and parolees? It could be a number of different reasons. For one thing, remember in an earlier chapter, probably 1, 2, and 3, that I stressed that you do not have to go to prison in order to receive a term of probation. However, you do have to go to prison in order to get parole. That, you have to understand, plays a big factor in recidivism. If you're already in prison, then you've certainly had something in your background that warranted the judge to give you a harsher sentence, or that offender a harsher sentence, than probation offenses. So a lot of times parolees have prior criminal history. And we know that as a criminogenic issue, that prior criminal history plays a role in recidivism. So there's a difference between state probation success and federal probation success as well. In fact, there's about an 80% success rate in the completion of supervision for federal inmates. So we're looking at 60 to 70% success for probationers in state and about 80% in the federal system. We don't always have to either release our offenders early or make a recommendation for revocation. There are many different options in between. That's one, we have on one end of the spectrum, we have revoke them. On the other end of the spectrum, we have release them early. So what's in the middle? We can do a number of creative things based on the violations that we see each offender have. For example, you can do modifications of supervision, and at times that can lead to an extended period of supervision. Maybe additional conditions. For example, if you have an offender who's hanging out with felons, okay? That's a standard condition of probation and supervision, that they are not allowed to hang out with other known felons unless they have permission from the probation officer. So let's say you caught your offender hanging out with other felons. I mean, that doesn't really warrant a revocation. It's not that major unless they're committing crime together, but that's a different issue. So what do? We bring them in, we counsel them, and we may ask them to voluntarily sign a waiver to modify the conditions of supervision. Maybe we would want to enact a curfew or restrict places that they can be, that we know they're hanging out with other known felons. Another modification would be if they have dirty urine tests. You may want to have them sign a waiver or modify their conditions to attend inpatient substance abuse treatment. That's an option too. So let's take a look at a couple different violations that we may encounter in the field that may lead to revocation, modification, or whatever the court wants, really. We're looking at law violations, technical violations, and absconding. I told you a little bit about technical violations when I gave you my practical examples of hanging out with other offenders or positive urinalysis. Those are called technical violations. I think I previously stated that there's around 17 standard conditions that apply to everybody on supervision. So anytime they break one of those conditions, that's considered a technical violation. Of course, unless it's a law violation, which leads me into my second violation, law violation. And simply put, that's breaking the law. It's any time an offender commits a misdemeanor or a felony crime, and it can lead to revocation or new criminal charges. The third type of violation is called absconding, and that's when they leave their supervision jurisdiction without permission from the officer. For example, when I was a federal probation officer, I was stationed in Southern District of West Virginia. So a lot of times during WVU games especially, people on my caseload wanted to travel up to Morgantown to watch games. Well, each time they did, they had to get a travel permit from me. And if they went to the games without permission, that's considered absconding. That's just one example. A lot of times offenders will abscond when they know they have criminal charges or new charges, or they might be violated. So they try to abscond because they're out of fear, really. So we have some other administrative options too. And we call those in-house intervention techniques. So we want to look at offenders who have made little progress finding employment. Maybe they failed to report. Maybe they didn't report for community service. And maybe they were wearing an alco sensor test. You know, it's an ankle bracelet that actually reads the sweat from a person's body and gives us an alcohol reading. So it's things like that, we can use some in-house interventions. And what happens is we orchestrate this in conjunction with our supervisor. And we come in, we bring the offender in rather, and the officer and the supervisor sit down, and they may give the person an oral or written reprimand. They may have staffings wherein you may have a supervisor, probation officer, and a counselor or some other people to say, here's what we need to do with your case. It's kind of like case planning. We may use some motivational interviewing techniques, and I want to encourage you strongly to read that because we do a lot of interviewing and motivational interviewing techniques in our supervision. Or we may just give the offender a directive, a stern directive. You will no longer do this. Sign this form that you understand. You will no longer do this or that. But let's say none of that stuff works. And as a last resort, we have to file the paperwork to have the offender's supervision revoked. Here's how it works. First of all, we have to look at the procedures that govern this. So we look at constitutional rules, state and federal law, and our agency policy. Then we prepare the work, the document, have our supervisor sign off on it, goes to the judge. If the judge approves it, then they can issue either a warrant or a citation. If it's a warrant, then they'll be picked up and arrested. If it's a citation, they just have to report whenever they have a hearing. But there's a two-stage hearing process. First of all, you have the preliminary hearing, wherein one finds if there's probable cause. Secondly, you have the revocation hearing. And a key point I want to point out here is that level of proof. The level of proof for a supervision revocation is far less than the level of proof for a new criminal charge, conviction. In a criminal case, you have to have beyond a reasonable doubt. In a supervision revocation, all you have to have is preponderance of the evidence. So like most of the evidence has to lean toward the fact that that offender is guilty of something. The offenders have several constitutional rights. In the Morrissey versus Brewer case in 1972 and the Gagnon versus Scarpelli cases are the two quintessential landmark cases that govern our procedures and policies for probation revocation. Some things to be aware of is that they don't have a right to a jury, no Fifth Amendment privilege, and so on. Just review your book for that type of information. Most of the time, as I said before, if we have 80% of the people that succeed on probation, who are those most likely to succeed? And what our research indicates is that women over the age of 30 are likely to be successful. Those with no prior adult or juvenile history convictions, they're likely to be successful. Offenders that maintain viable employment, and employment is key, and I know I previously lectured on that before. High school graduates and those people living with a spouse or children. So being young, unmarried, having a prior criminal history, and lacking emotional maturity all contribute to higher failure rates. And that's going to conclude my lecture on Chapter 7. Thank you so much.